Will Basics for Washington State. What is a will? A will is a legal document. It helps your family handle your affairs after you die. In your will, you appoint someone you trust as an executor or personal representative. Your will tells your executor how to give out or distribute your personal belongings and other property. Your will also gives your executor the power to pay any debts you have when you die, like loans, credit card balances, medical bills, etc. After you die, who will get your coin collection? Who will get your grand piano? Who will get your car? Your will helps your executor answer these questions. After you die, who will pay off your car loan or your credit card bills? Your will gives your executor the power to do these things too. Why do you need a will? A will helps you decide now how your affairs and property are handled after you die. It can make things much easier for your family and friends during a difficult time. For example, Uncle Harold and the grand piano. Let's imagine you own a beautiful grand piano. With a will, you can make sure your grand piano is given to the person you most want to have it, your favorite uncle, Uncle Harold. What if you die without a will? If you die without a will, a situation called dying intestate, Washington state law alone decides how your affairs and property are handled. This process is complicated and may not handle your property in the way you would have wished. Without a will, Uncle Harold may not get the grand piano you always wanted him to have. Do you need an attorney? Washington state law does not require you to hire an attorney to help you write your will, but it's a good idea to at least talk with one. What a basic will needs. These are the minimum requirements for a valid will in Washington state. Again, the laws concerning wills and inheritance in Washington state are complex. You should consider consulting an attorney for guidance and advice. At a minimum, your will needs to be in writing. Your will needs to appoint someone you trust as an executor. You only need one executor, but it's a good idea to have two. The first is called the primary executor. The second is called the alternate. If the primary executor cannot do his or her duties, the alternate can step in. Your will needs to be signed and dated by you. Your will needs 2 witnesses. They must be adults you trust and who are not going to receive any gifts from your will. These witnesses must watch you sign your will and must also sign it themselves. Do you need a notary public? Washington state law does not require you or your witnesses to sign your will in front of a notary public. This is an optional step and is called making your will self-proving. It's a good idea to do this. It makes it easier to prove to the court later that your will is authentic. Self-proving your will. You and your witnesses agree to meet with a notary public. The notary public and your witnesses watch you sign and date your will. The notary public also watches each of your witnesses sign and date your will and sign and date a sworn statement called an affidavit. The signed affidavits are kept together with your signed will. Where to keep your will. Keep your signed will in a safe place, such as a safe deposit box where you keep your other important legal documents. If you chose to self-prove your will with affidavits signed in front of a notary public, include those affidavits. Alternatively, you file your will and any affidavits with the will repository of your local trial court. What if something changes? If you need to change your will, it is best to write a new will that revokes the existing one. The new will should include the changes you wish to make. It must include all of the minimum elements described earlier. Learn more about wills. You can learn more about wills for Washington State at the following websites: